still on FM 93.1, News Radio WFLA Orlando, and still on AM 540. And now for our weekly look at legal issues in the news with our in-house legal expert, attorney Tom Olson. This is Olson on Law.
Yeah, we do it every Thursday at this time. We bring you Olson on Law with longtime Orlando attorney Tom Olson. Alan Spector here along with Tom. Good morning.
Good morning, Alan and crew and WFLA listeners.
All right, our topic this morning is one that actually I encountered along the way, and we might get into that as we discuss it. But it's whether parents should add the name of a child or their children to their bank accounts. Now, why would a parent want to do that?
Generally, they do it for two reasons. One would be so that the child could pay their bills if they needed to, if they were in a car wreck and comatose, for example. And it's also a tool to avoid probate, but not a good tool to avoid probate.
Yeah, and that's what happened to me. I actually had added the name of one of my children. I've got 3 children to my bank account, thinking, okay, at least if something happens to me, one of my children at least has access to the funds in my bank account. I don't have to worry about it being frozen or taken away by the state. And then I was told by a lawyer later on, nah, you really shouldn't do that. What are the problems with that, Tom?
The problem is if the child gets sued, works up $1 million in medical bills, doesn't pay their taxes, files bankruptcy, gets divorced, has a terrible automobile accident, child's creditors are coming after parents' money because a child's name is on parents' bank account. The other problem is that if you've got 3 kids and you have just one of them as a co-owner of your bank account and you pass away, that money will legally belong to that one child, and he or she will not be required to split it up with their siblings. And I find that to be a problem that when mom passes away, that sibling, that child keeps all the money and does not split it up with his or her siblings.
So is this never a good idea? And what should parents do as far as their bank accounts are concerned?
So on an everyday checking account that has less than $10,000 in it, I'm okay with you add your child's name to that account, maybe one or more of the kids. But as a general rule, we prefer that you keep your bank accounts in your name only. As far as getting them access to that money to pay bills that they need to, get a good financial power of attorney. That will give them access to the funds. And as far as avoiding probate on that bank account, you can make it POD, payable on death to your children. That is a great tool to avoid probate on bank accounts. Checking, savings, CDs, and investment non-IRA accounts, make them POD, payable on death.
You mentioned an important word there, probate, Tom. And I know in your show you've discussed how to avoid probate, and maybe that's something we can get into on a future episode of Olson on Law.
I'd love to, Alan.
All right. If you have legal questions about just about anything, Tom will be happy to answer them on his Olson on Law show. That is heard Saturdays at 1 p.m. here on News Radio WFLA Orlando. Tom, thanks so much.
Thank you,
We'll
Alan.
see you next time. Remember, for all of your legal needs, call the Olson Law Group in Orlando.